the doors now. Good evening, everybody, and welcome to the Wednesday evening seminar. Tonight we're joined by Mohammed Haque, and he's going to be talking to us about how to get through ADR, Alternative Dispute Resolution. And if you have any questions, Mo, please keep these till the end of the, or you can put them up throughout the presentation, but he'll answer these at the end. You can use either the Q&A or the chat facility in the bottom toolbar. Alternatively, if there is something you'd like to ask Mo, but don't particularly wish to do in an open forum, you are always free to email him. You'll see his email on the screen there, mohammed.haque@fletcherday.co.uk. He's always happy to answer direct emails from you. Okay, over to you, Mo.
All right, thanks very much, Julie, and welcome all of you who are attending this evening seminar of us. It's regarding ADR, which is Alternative Dispute Resolution. In the title, it says, get through ADR and keep your cash. What it means is that, well, there are political rhetorics and so many good ideas and philosophy that we have to go resolve things, not be adversarial, win our cases, resolve our cases, settle our disputes, and all these sort of things. But keeping those aside, there is a very good reason why you will choose alternative dispute resolution, meaning the disputes to be resolved through a process other than court litigation of some sort. And that's cost, because cost of litigation is very high. It starts with the payment of the court fees in order to get into it. So that's a mandatory thing for the party initiating it. And it's not a small amount of money in England and Welsh, it's based on a percentage basis, and it costs you a lot to start, apart from the party costs and all. Then the second thing is, of course, you are forced, most of the time, cost to follow the event. So you are forced to pay the cost of the other side, and which may be a huge sum in a relatively smaller litigation. And that sometimes, you see, allows the parties to decide, or forces the parties to decide not to go to litigation. And as we'll see, the mediation process has been used by the English courts as a means to cut down the number of issues when parties get into the adversarial mode, because sometimes they keep on challenging everything. Nothing's going to go unchallenged. Why you are wearing the blue coat and you are supposed to do a green one, that sort of thing crops up. It's because that's the nature of the game. No one's to be blamed, but you got to be sensible and find a way out to cut down. So it's something like mediation is evaluative, and it's been developed to be a part of the English litigations, so that the parties evaluate at least one last time, and reduces the number of issues. By issue, I mean simply a matter on which parties disagree or differ, and they want a determination from the tribunal. So what's the bag? The bag is unlimited. You have wide variety of choices. It's not a set meal that, okay, there you have this and you can only go for a writ or an originating summon. You have hundreds of different types of possibilities. Well, I mean, 100 may be a bit of a stretch, but a good number, a good few options are there in your hand. That's the first thing, because see, we live in a world where we want to choose, and also we have like tailor-made things for which suits the need of the parties, because it's a question of ownership. They're the owner of the dispute, and they can decide how detailed or how informal they want to be. So it's something like first good thing to talk about is you have choices. So I've listed 1, 2, 3, 4, 5, 6. However, that 6 is not the only one. I've not discussed negotiation. I've not listed, because otherwise the slide would have been like full of alternatives. I've not discussed, um, um, for example, amendment level settlement or dispute tribunal. I've not discussed many other created by the contract or certain office where you can go to and do. But at least I've done the bare ones, which are there for years, and there's this cap at the end of the list. If you are doing my lectures regularly or webinars, attending regularly, you know that I'm a keen advocate of this cap. I'm involved in it right from the beginning when the idea has become popular. And obviously, if you are more interested about it, we have already done 4 with RICS jointly, and all of them are in our YouTube channel. You can have a look. But we have this more or less choices available to pick up. So it's not that, and when to make the decision, of course, you can make the decision at the time, and it's better advised to make the decision that which one you want among the ADR processes at the time you're entering into the contract. And a section is quite common in construction contracts to have noted the intention of the parties, where do they want to go to. But it doesn't necessarily have to be that. Adjudication is something that's implied, you cannot avoid it. I'll discuss later on mediation as well. On certain occasions it's semi-compulsory. But then arbitration and other modes are your choice at the moment. And even if you haven't made those choices, there's no harm. As and when a dispute starts and you are thinking that you and the other side of the contract are not in a position to settle it between themselves, and you want to bring in a third party, and you want not to go to the court immediately, I would say explore the opportunity of an ad hoc agreement, either to arbitrate, to negotiate, to mediate, to adjudicate. Well, adjudication is mandatory, so anybody can go without taking any consent from the other side, or determine it through an expert, or go through a cap process. So all of these I'll go one by one, and just to give you a brief idea, but I'll be focusing mainly on adjudication because that's my bread and butter. Of course, I was fully only involved in international arbitration for the first 10 years of my profession, and I was acting as a counsel, mostly in international disputes of construction contracts, of course in other commercial contracts as well, but mostly in construction contracts. So I have some idea, but because we're in England and we primarily go through adjudication, despite we are trying hard to people to go to cap or expert determination. I like both of them. I've done expert determination when I was in Asia, and it's a fantastic thing. And RICS is about to formulate a panel. If they do so, then we'll have a better supply of neutrals who would be ready to help parties. But as I said, by and large, most of the disputes, when it goes to or enters a resolution phase, it goes to adjudication in England. So I'll be focusing on adjudication more than the other ones. Now, starting with arbitration, I'm a fellow of the Chartered Institute of Arbitrators, so the first institution around the globe to start or they initiate the concept of arbitration as a whole, and of course, in construction matters. See, a few engineers, non-lawyers, they sat together, not very far from where I'm sitting and giving this webinar in Reading, and I'm in High Wycombe, it's just stone's throw. and they decided that it's time that we have a better informal process in our hand to resolve the disputes, if at least those which are with the issues of which are non-legal in nature. And they formed eventually into the Chartered Institute of Arbitrators, and they've extended their wings. But because of that, very initial members have dreamt to have a arbitration process for the primarily for the construction dispute. So many practitioners of CIR are actually construction lawyers or other type of construction professionals. The beauty is not only that it's a private matter, and the arbitrator's time is paid by the parties as he spends, and that's agreed in the in advance, and the procedure more or less can be agreed between the parties even in advance, and in consultation with the arbitrator even, that how detailed they want to go. They can decide the number of the arbitrators and all of these. Well, people talk about all these things, and privacy is a huge thing, because sometimes people do not want to go to public because of sensitivity of various sorts. Sometimes different parties are from different countries, and they are hesitant to go to the courts of one of the countries, feeling that they're never implying that the courts will not be impartial, but still they have a feeling that they might be biased to their own nations, the party of their own nation, be it an employer or something else. So to just save all these, people do prefer arbitration. I understand that. But the real beauty, in my understanding, is for the construction disputes. See, you have, and that runs through the entire thread, you have a construction professional as a member of the tribunal. That's the beauty of this whole thing. That has been the four corner of the thought, the anticipation, the view when it was first established, and it's still running with that. Because if you go to a court, the judges are judges, they're very good professional lawyers, and they sit and they've practiced for ages. But if it's a construction matter, there are two ways of resolving it: through the evidence and its credibility, and alternatively, by even the tribunal understanding the technicality of the matter. Now, if you're in the court of law, 9 times out of 10, the judge will not be, a construction background professional, so in the sense that he knows the technology of construction. So what will he do? He will rely on experts from party, and supposedly they're neutral, but I don't want to get into that neutrality, but they will be representing parties. And the poor judge will have to make something out of it. I'm not saying it's not difficult for them, or it's not impossible for them to come to the right conclusion, but it could be that if the judge is a construction professional, then he would be able to understand what these experts are saying much quicker, and also the experts will be much more hesitant to mislead the tribunal. I'm sorry if any one of you are experts. I myself sometimes write expert reports, but so there is a view in the market which thinks that, okay, the experts are just there to make water muddy and getting more complicated. So if there is somebody who, the arbitration panel or the sole arbitrator, who knows construction, to me that's a great help, other than through the legal discipline. Okay, so that's, to me, is the beauty. However, arbitration, not from a legal perspective, but from a practice perspective, has become equally formalistic as court litigations are, and it takes not as long a time as a court does. Sometimes it takes more, but obviously these are very big disputes. However, it's sometimes very expensive as well, but obviously not compared to court again. If you sometimes people say, oh, some of the arbitrations we had to spend this much. No, take into consideration if you had gone to litigation, how much you'd have spent. And only then you'll realize why arbitration cost-wise is also. So again, the point is, not only it's good, it's efficient, it gives you choices, it gives you privacy, it gives you, it may save time and complicacy, but finally, you save money. There's no doubt about it. I mean, if you do an apple-to-apple compare, that if I go to litigation for this and if I go to arbitration for this, arbitration still, that's the most expensive method, yet will be among the ADR, I mean, will be much cheaper than going to litigation. But mediation is actually, as I said, in the recent past, it has become more of an evaluative thing. People test their issues, their evidence, their inconsistencies or consistency, where is the other side stand, all these things, because you have the freedom. The mediator can actually go away and talk to one of the parties. And again, he or she being an expert, try to explain that, look, the other side doesn't know, but have you looked at this? This is an inconsistency within your evidence. That's the beauty of mediation, that an expert which is neutral and who's trying to convince you to come to the right case you have, can explain to you in private, not in front of the other side. And then again, he goes back. And similarly, he listens to you, tell me what you want. What's your bottom line? And he asks the other side as well. So he, privately formulates, the gaps are not that much as has been thought by the parties. And as we know, if we are trying to go to the business court of TCC, Queen's Bench Division, TCC, of which TCC is a part, with a litigation, we got to send a pre-action protocol as a matter of routine procedure. Again, they may not be mandatory, but it's like have to be. And then as soon as you send one, it's a common practice. There's a reason for the common practice to make a mediation effort. And if the other side doesn't agree to, there's no immediate sanction, but there is a sanction at the time when the cost is assessed. So for these reasons, even if you think, no, I know my issues, I don't care, the unreasonable party other side, I'm going to court and I'll see him. And like it happened yesterday, actually, in the afternoon, a Tesco driver came to deliver something, and somebody, an old man, he was complaining a lot, and the driver was a young fellow. He was, at the beginning, he was laughing a lot, and then the guy got irritated and he said, I'm going to call the police. I said, okay. I was nobody, but even then I said, okay, you call the police, they may not come. And the guy was saying, okay, then I'm going to the court. I said, in this around, it was about 6:30. And I said, well, which court shall you go to? And the guy didn't know, of course, they're a legal professional. I think Tesco guy was laughing as well. But no one could make him understand that this is something like they have the right to park the van anywhere to deliver. He was saying what you're doing is illegal. So sometimes people get sort of emotional about disputes, and they say that I don't care, I'm going to see you in court type attitude, I'll and start feeling that I'll do the drama as we see it in Hollywood or any other famous movies. Mediation is the opportunity to sort of force them to go through that process and gather the parties and talk to them individually, and then slowly trying to take the emotion out. And something, if you repeat your emotional statements a few times, that means you're allowed to ventilate. Of course, you don't understand, the mediator is nothing but a wall. They're listening, but they're not actually giving any damn to your statements. But because you're given the opportunity to ventilate, so happens that parties can see the woods through the trees and starts realizing the reality of the matter, takes the emotions out, so that at least brings down the issues. And sometimes, if you're lucky, they also agree to the desired consequence and they settle. It's not mandatory to agree, but many times they do. And if they do, they actually agree. There is no such thing as a mediator's decision. Normally, only in cases where they do not agree, the parties do not agree, then an observation is made sometimes at the request of the parties. But most likely that a settlement agreement is drawn and it is signed, and that's how it becomes a contract. The decision actually is nothing but a contract. There isn't a decision, there is a contract, and the settlement contract, that's it. So conciliation is more or less the same, and it's a bit like more formal a process, out of court dispute resolution, and a neutral third party will assist the in a confidential way to the parties to reassess their cases and try to develop a settlement, you know. So both are more or less the same. Remember that if you are taking the route of litigation, as I said, a mediation is almost a must nowadays. So the court process has found a way to force you to go to a mediation, and there are good reasons why you should do so. You will save money straight away, because you'll either be sure that no, your issues have validity, because there's a neutral third party who's looked into your issues and the other parties choose their evidences, their arguments, everything separately. And then, of course, within the limited way that person will suggest. So you get a better kind of view, you know, of it. And if you are lucky enough, if you can settle, then that's a very good thing. So that's that. And I come back to adjudication. Of course, before I go to adjudication, I'll once more just mention the cap. Cap is a process which runs parallelly with a contract's operation. So if you find the whole aim is not to allow, and there are things like DAP, which Network Rail has developed in all their contracts, which is even a stage ahead, you know, trying to find out if parties are in dispute. So what they do, if cap is invoked, or attempted, and then the parties agree, okay, let's go to cap. An expert is supplied by RICS, who's running the process, who's a very, very eminent senior professional into the country, but ages of experience into the sector and the matter, and very good authority on the issues. So he sits down, and parties come in and they discuss everything freely, okay? And this expert guides them. Look, if this is what you're saying, why you are not considering that? Or do you have this thing? Do you understand that this argument has the problem of that sort? What does the contract say? What evidence do you have? How far it's possible that you'll be able to convince the thing? And many a time, it's very, very cheap. In 3 days, 4 days time, and sometimes keeping 3-4 experts at a time in a panel. Like I say, DAP is for Network Rail. They develop CAP's product in DAP for their own institution or an organization. What they do, they sit in advance when they start operation, that what are the obligations and what are the risks, who is responsible for what, who will be responsible if something goes wrong. All these things are charted in front of third-party neutrals. Then what happens? You know your contract better, you know the odds of it, and where you have an opportunity to earn some money. So you would not fall into the disputes that much. So it reduces. It's not an easy task, but it reduces the number of disputes very nicely. And at a very low cost, unimaginably low. So if you are thinking about, and which is, I would say, very important for you to consider at the moment, that the cost you're going to incur in doing any even ADR, it doesn't matter whether you have included cap in your contract. Do give it a consideration and ask the other side that, well, we are planning to go to an adjudication. Why not a cap? Why not we sit down and try to avoid this conflict in front of a very high-ended expert, locked down in rooms for 2-3 days and sort of discuss very openly without prejudice who has what, and try to bring a solution of some sort, And obviously an adjudication cannot be a futuristic solution like, okay, I'm giving you another contract, or anything like that is not possible under adjudication or even mediation. But the cap, that could come as like a part of your settlement negotiation. So that's something also to be considered, but that's that. Now I will jump onto adjudication, my main business. I've got half an hour in my hand. Hopefully that should be enough. Those of you are interested, I've been doing a series right from the beginning of the year, adjudication matters, and possibly each one of the issues I'm going to discuss today, I've discussed it or will be discussing in 2 more parts I have. So you have all the choice to go there and learn them in more detail. But today is a brief synopsis of what I have provided throughout the year or going to be provided later this year. So this is the advantage of adjudication, that although it's interim, it's only binding till someone goes to a court of law and get a decision, a final decision, or do an arbitration. But more and more disputes, more than 60 or 70% of disputes, if once adjudicated, that's becoming or getting finality. And at the most, the decisions are challenged or what you say, enforced. And remember, adjudication is the only form where an adjudicator's decision will be enforced by the court, even if he decided it wrongly, provided he decided the right dispute. And the parties will be told, the loser will be told, please pay now, and if you have still problems, go to court. And I tell you, I've been in adjudication for about last 12 years. I'm just 9/10 of my work is adjudication. And I'm an adjudicator myself, and being a member of the President's Panel of RICS. As I saw, people, take a very aggressive approach at the time they're presenting a case. But end of the day, when a decision comes, people can see that these guys are experts and I will have little to achieve. I'm not saying in odd cases, people do not make mistakes. So even last month, we have had a case where one of the very, very senior adjudicator, I would say, somehow made a mistake about natural justice. He failed to consider, and he unnecessarily complicated his course by deciding not to consider one of the defenses of the responding parties, which was, I don't know why. I mean, I've learned adjudication and many things from him, but somehow it happens. People, to err is human nature. But by and large, when an adjudicator gives a decision, say for instance, I've been in the President's Panel for more than a year now, what is my experience? About 24 years experience of construction law in Asia and in England, and of which last 11, 12 years are English adjudications. I've got overseas international adjudications before that as well. So, I mean, even if as I am one of the the top idiots into the profession, or the profession has ever created, even then, despite all my efforts, I couldn't keep myself confused for 24 years. And I can see what the intended results gonna be, or what a court will behave like. I was just before coming to this, I'm sitting on an adjudication or repudiation of a contract, and I was dealing with a jurisdictional challenge and a matter of interpretation raised to me by one of the sides. And I was sort of thinking that maybe 20 odd years ago, I would have given similar arguments, but I won't now because of my experience. So these are very highly qualified people. So it doesn't matter that they don't have the right to discovery. It doesn't matter that it's only a 28 days or sometimes extended up to 42 days. You know, they can, if they want, understand the depth of it because they're experts in their respective line. You know, so that's the beauty of adjudication. And again, I'm telling you, all way too cheap than any other mode. I tell you, the adjudicator's fee, the party fees, altogether won't cost you more than 50, 60,000 pounds for a dispute up to, I mean, one of the most complex dispute up to £1 million. So if your claim is around £1 million, you can be very happily or be sure that you can close it down by spending 50, 60,000 pounds, both for your lawyer's fee or representative fee, as well as the adjudicator's fee. Okay, if you win, the other side will pay the adjudicator's fee anyway. So you get a very clear understanding of where do you stand with your dispute, which you should have earlier anyway. But anyway, you will have it in 28 days time. So, and you do not lose the right to litigate. If you really think that, okay, the adjudicator doesn't understand anything, I'm the one who understood it, one of my clients used to, and when I refused to represent him in the High Court, he personally went and started a case in the High Court, and eventually in front of Lord Justice Paulson, he was the TCC, then lost bitterly. But point is that at least when the adjudicator's decision came in, he didn't even accept, but I again told him that, look, you don't have a case. So you actually understand where you are by spending some money and with a quick period of time. And if you are actually doing the case correctly, you also get your cash at a very cheap price. So that's that. And I've already discussed about the enforcement, that the adjudication awards are enforced by the courts. And as I said, these are enforced even if they're wrong, unless you can establish that the adjudicator didn't have jurisdiction. The courts do not care. And that's how representatives sometimes just create, with all their ingenuity, some sort of jurisdictional challenge, a natural justice challenge, which court are equally happy to reject. So so that if that's what goes through your mind, if you want a cheap, rough justice, as they sometimes say, keep your cash and get through ADR. And this is post-Brexit, neo-normal, post-pandemic scenario. And you know better than me how important it is to save money. Every penny counts at this point of time. So why throwing? And we are actually discussing with CAP Coalition to actually make a representation to the Cabinet Office that for the time being, for 3 years or 4 years, ADR should be made as the only method available in England for construction dispute resolution. And I was told by my friend Martin Barnes from RICS that there is legislation already in place coming to be approved by the two houses, where in other sectors the same route has been followed. So even if in other time you wouldn't have been bothered, now it's a good time to think of it, So which claim to go for? Of course, payment disputes, interim payments, final account disputes, extension of time, liquidated damages claim, or loss and expenses. These are quite normal for the adjudicator, for the parties to adjudicate. But remember that you cannot claim or include a claim in tort of negligence, or for misrepresentation, or for rectification of the contract due to mistakes, because these are not claims under the contract. In an adjudication, it presupposes that the claim must be under the contract, meaning that you are entitled to some kind of relief under the terms expressed or the implied terms of the contract, or the other side is in breach of the expression, the implied terms of the contract, and that allows you to get some remedy like damages, or avoid paying damages. So, or an injunction or a declaration. More and more declarations are being sought in adjudication nowadays. But if you are claiming like, okay, you don't have a contractual relationship, it's a dispute arising out of a contract, but under the tort of negligence or some other tort, adjudication is not available. Similarly, if you say the party has made a misrepresentation, then you are doing a suicide, then it's a voidable contract, and you cannot sort of resign the contract. Same is for a mistake. If you just kill yourself if you plead this. So please, if you that's what you're trying to say, that this contract is not valid or vitiated or voidable because of misrepresentation or mistake, just you cannot go to adjudication. But other than that, if you can see, if you read through your contract, and if you see one of the terms of the contract gives you some rights which you think you are not being given to, or the other side was in breach of, yeah, that's the perfect dispute to go to adjudication. It doesn't matter if it's a low value, because nowadays we've got low value adjudication separately dealt with, where the adjudicator's fee is capped. And lately this summer we had, and I did a couple of them just to assist RICS, all the disputing parties, where they were, I think the cap of the summary proceedings were something like 25,000 or something. And it was a 14-day procedure. So, you know, I mean, simple cases, and I think there were £1,000 was allowed for the adjudicator, and limited submissions. Same is nowadays available under TEXA, under CLC, which RICS is running. We call it LVD process. So sometimes it's less costly as well if your dispute is not of high value. So at least the adjudicator's fee is capped, so you know how much you're paying, and there are parties or representatives who deal with low values who are not very expensive either. And in any case, as I said, if you consider and assess your claim properly, in that case, you will know where you stand, because any experienced representative will be able to tell you the merit of your case. Okay. Well, of course, adjudication is under the contract, and the main difference between a contract and a scheme is, let me just discuss that briefly, that the contract does only come into place if in England and Wales, if the site is in England, it doesn't matter if the parties are overseas or whatever, and you have even the contract is entered into overseas, it doesn't matter. You know, if your site is here, and if you have a contract that's defined, that attracts the Housing Ground Regeneration Act, Construction Regeneration Act 1996, then you cannot avoid adjudication. But if, for instance, it's a construction contract, but it's an excluded construction contract, there's a list of contracts which let's say you are manufacturing an industrial plant or a similar thing, nuclear power generation plants. There are exceptions, so the water utility plants. Although they're pretty much a construction contract, but they're excluded. And then, of course, there are hybrids as well. So only if it's excluded, then there's no problem. You can still do the adjudication by adopting the scheme, agreeing that this is part of the contract. So that's how the contractual adjudications come into being. Or you can draw your own like FIDIC has, own adjudication procedure to be followed. And even in contracts, which are construction contracts, you may have your contractual version, but that must comply with the Housing Grant Construction Regeneration Act Section 108. And that's how more and more people are nowadays saying, why bother to draw a procedure and then fall foul and then go to scheme. Let's just agree that scheme is going to govern us. So that's all. And this is primarily the procedural aspect. So you've got to take a note which one applies to you. So even if somebody thinks, it's an excluded construction operation, I can't adjudicate. No, you can, if the contract says you can, or if you make a proposal to the other side that this is the cheapest possible opportunity to resolve it, although it's not there in the contract, let's go there. And if they agree, that's it. No one can stop you. You're a contracting party. So how it happens, there is a notice of intention to adjudicate first sent, and then once sent, you can then ask to one of the adjudicator nominating body immediately after sending it to the responding party that I want an adjudicator. And they nominate within a couple of days normally, although there are 5 days, that's the normal norm, but they do it in no time. And once the adjudicator is nominated, you, the referring party who's initiating the dispute, has the right to send the referral. The time gap must be between the notice and the referral day is more than 7 days. It doesn't matter that you say you've asked for an adjudicator today, you've got it tomorrow morning, you have all the right to accept and send in back the referral tomorrow morning or in the afternoon if you're prepared. No one can say that you have to wait up to 7 days. And the day you send the referral, that's the day zero, and 28 days will be added to that day zero for the adjudicator to decide, unless the referring party extends it to 42 days under the scheme. He has the power to, if the adjudicator or he voluntarily thinks he might do that. Funny enough that the scheme doesn't allow any response, but it's tried to law now that adjudicator must be neutral and must follow the rules of natural justice. So he must give an opportunity to the responding party to respond. But there is no form, no right under this scheme for the responding party. Sometimes it happens that to cover up this gap, some people into their contract, they write down that they will have, in such a case, they will have a right to respond as well, responding party, and they prescribe a time limit for that. Of course, then you have, as soon as the response comes, the fashion is the referring party says, I wanted to say something new. The respondent said something new. I want to answer to that. And it's pretty common or a typical fashion that a reply will be allowed. And sometimes if the reply then goes on to new things, a rejoinder, the rejoinder may follow as sa rejoinder. And sometimes if the dispute is complex and you need to do a site visit, the adjudicator may do that, or hold a meeting. We don't call it a hearing, meeting, to clarify things between them. Mostly the referral should state the case. There's no hard and fast rule what to do, but you have to state the case. You have to give your the statutes and the case laws you're relying on, extracts of them. You have to give sufficient evidence to support your facts you have claimed, and must ensure that these are not inconsistent. If you do not have any other statement or material or real evidence, you might get some witness statements as well to support your case, or sometimes to clarify. And sometimes the expert reports are added as well, where opinion evidence is needed, or where clarification of various factual evidence is needed. So that's more or less the bundle. Enforcement, once the decision comes, you have got right to apply for under the slip rule of this scheme to correct any typo. But other than that, if that's not there, you can then go to enforce it. Various methods, because there is nothing the scheme has said that what you should do to enforce it. So a reference is made to Arbitration Act. However, in the two cases cited, Maker Civil Engineering, Morrison Construction Limited, and then the famous case of Bogus Limited, which said Dahl Jensen or Jensen UK Limited, it's been made very clear that parties need to follow a particular summary procedure developed by the TCC to enforce or challenge this decision under Part 7 or Part 8 as the appropriate thing is. And normally declaratory reliefs are sought. So that's it. That's the only thing you should follow or go to. Not any other smart thinking is needed, because it's been pretty obvious that this is the best and the shortest possible method to follow once you have a decision. And what arguments can the defendant put forward to defend the application for summary judgment? Well, when you go to the TCC and say, this is an adjudicator's decision, please enforce it, they will say, the other side will say that, well, the adjudicator never had jurisdiction because there was no contract, because he was in breach of the rules of natural justice, because he didn't follow one of the mandatory requirements of the scheme. For instance, the decision had to be there by 28 days and he issued in 29th day, so on and so forth, you know. Or the dispute is the same as one which has already been referred to adjudication. Be serious, don't argue, it's not going to work if you say that the dispute is same as has been litigated earlier. Less chance to succeed. But if you can show that the dispute is the same as one has been adjudicated earlier, yes, you have got a good thing. And in the current days, it's getting more and more popular as a natural justice ground. If the adjudicator failed to consider a defense, and remember that in a payment adjudication, you still have the right, because the money is, they asked for money, the referring party, you still have the right to seek a set-off on evaluation ground. Okay, if you have the evidence ready, has the argument in your hand, you can go ahead. And if the adjudicator doesn't consider that, he's in breach of natural justice and his decision will not be enforced. So finally, if the adjudicator has answered the wrong question, okay. Well, sometimes we adjudicate on and then decide, and then it's found that the adjudicator has some kind of a fault in deciding, other than natural justice or bias. I'll not repeat bias here, because bias is actually part of natural justice. What actually biases should have been conflict of interest, or some sort of fitness issue of the adjudicator. For example, going on his own frolic, a case he's trying to decide which has not been referred to him, or fails to deal with a matter that was in the notice and referred to him, or if the decision is unclear, because if it doesn't give sufficient good reasons, it reached an illegality in the sense that it breached seriously the scheme, and all these might come into show from the defending party. So remember this other thing, it's very important. If you have like a claim under the express terms of the contract, be it, or even implied terms from the statute, like the payment terms, or extension of time, or loss and expenses and things like that, the whole thing flows in a particular manner. If it's a breach and damages, it's somewhat different, because normally the contract has a process involved for the express term breaches and the claims. But common law breach, it has to follow like a pre-action protocol type legal letter, and then discussion and then their claim, you know. What evidence and what record? That's something. It's not. We are not talking about the day when the adjudication starts. We're talking about the day when the contract starts. I would say note taking, meaning that try to understand your contract as soon as it's entered into. That's the first important thing. And then by that, I mean that take the signed or unsigned contract and then all the schedules, all the references that has been made within the contract, review it, make a track sheet of the contract to understand who's responsible for what and who's responsible to follow a procedure. What are the procedures? So that detailed working will help you later on to sort of be able to point out to any third party neutral that this is what I'm talking about. This is the dispute under the contract. And of course, everything do in writing, okay? Contemporary and writing, okay? And one of the major thing I find, at least in JCT contracts, you complete the work, the contractor, the quantity surveyor comes in, the CA, the contract administrator comes in, they say, oh yeah, it's okay. And they allow the works to be taken back. I would say, no, don't do that. Create your evidence properly at that point of time, do the tests and keep a quality check on it. Like NEC provides the supervisor's role, who's the man for quality into the contract. But no standard of proof about adjudication, well, it's a civil matter, a balance of evidential rule of balance of probability, or in balance, decision, these things will be decided. The burden is, of course, one who asserts must prove, but it changes if the other side's takes on. Forms of records, there's no rule. Formality is not an issue here. Anything might be part of, as long as it's contemporaneous and genuine. Of course, photographs and videos are very good. And letters and correspondence help, sometimes doesn't, because it says things inconsistent from what you're trying to say. And of course, sometimes archived ones are also brought in, or system records are also shown to the adjudicators to support the cases. What do I need to think when I'm compiling the evidences? The important thing is to remember that this is a piece of letter, so what? Just do not start saying, on such and such day, he said this and I said that, and then John said that, and Linda said that. It doesn't take us anywhere. You are claiming for an extension of time. Give the adjudicator the delay notices. Give the adjudicator why the delay notice was correct, the relevant fact, and then only give the records which support it. It makes the adjudicator's life easy, it makes the other side's life easy. Similarly, if you're talking about, even today, I'm doing a claim of loss and expense, and I'm asking my client for a prelim item, they are claiming that give me the reference value into the contract. Would you believe something like scaffolding? They can't provide a reference value into the contract. What does that mean? That means they have taken on their shoulder the risk of the scaffolds. Now, I can't claim the scaffolds anymore for the contract period. I can always say that due to the breach of the other side, the contract has been extended, so I've got no duty or a risk of a duty to carry on the risk on my shoulders. I'll be adding, but such a fundamental mistake. Scaffolding was not included into the prelims, and in a contract where the employer has sent you a bill of quantity type Excel spreadsheet, which more or less adds everything or includes everything we have in the NRM. Even though that's there, they failed to add up the item scaffolding, and they said, it was so minimum, we thought we'll be able to manage. And that is now 250,000 claim for additional delay. So, you have to understand that a matter is relevant if you are claiming that has caused the problem or that has allowed you the rights. And once that is your claim, please provide the document which supports it. Do not just sort of send bundles after bundles for nothing, okay? You'll be doing injustice to your case if you do so. But unfortunately, we receive such and for nothing. So, well, I mean, I think I have discussed it enough of importance of record keeping. Again, as I said, it's in the light of arbitration, but as I said, forms of records, although the contract may demand or notices are demanded to be done formally, don't bother about that. If you are in ADR, be it adjudication or arbitration, yes, if you have done it properly, following the contract procedure, fine. But just because the delay has not been notified in a formal notice, it's not a big deal. It's still important. It still will be taken into consideration by the tribunal. Same, even though a contract document requires a procedure, unless it's something like a variation. Even in variation, if the employer just takes back the work and put it into use, and if they have requested it, just you can say even verbally they have requested it and then took it back, chances are you will win it. But these records that it has been the work was requested and then it has been taken back is vital. So I will not bother you with the forms of records and the notices. Well, if you are in hindsight, of course, this is a very good thing to do, but the key thing is contemporary records. So whatever has happened into a site on a daily basis, keep records of them. In whatever scratch way, in a dictaphone, in a typed manner, in a diary, doesn't matter. If you have that, and if you tell them that, oh, this is where there is a delay event, and this is where I think 7 days will be needed. It doesn't matter if you have texted, you have WhatsApped it, you have done it on an email, and the contract says you have to issue a formal notice. It doesn't matter. Well, there are exceptions, of course, payment notices has to be like that. But by and large, I'm saying, okay? So that's, even payment notices are things. Again, forms going on, and you have the slides, you can take notes from them. But the key issue to take from this lecture is you need to have some kind of record, not formal record, obviously, timing and all this, okay? So I think I will not go on this practical points anymore because I'm already over time and I want to finish it here, okay? Thank you very much. And if you are in adjudication, come back to my normal ones.
Okay, thank you very much, Mohammed. Yeah, there was some slightly repeated information in the latter slides there. If anyone has any questions, now is the time to ask. Otherwise, it's just to let you know that tomorrow night we have John Sharp, who is doing the first of his construction and insurance case law updates. So interesting case law from this year that will be making an impact in either the construction or or both the construction and insurance sectors. If you'd like a place on that, please email us seminars@fletcherday.co.uk. Next week we have a case in point live, which is with Mohammed on Tuesday. We have tools and techniques, And then we have changes in construction contracts, the valuation and other implications, which is again with Mohammed. That's the second in his new series there. As with all, just email seminars@fletcherday.co.uk and we will happily get you booked in for all or any of those. Okay, without any further ado, thank you to everyone that's attended this evening, and thank you, Mohammed, for yet another interesting presentation. And we hope to see you all again very soon. Take care, everybody.